Seated next to me is Dr. Tara Smith, professor of philosophy at the University of Texas at Austin, where she specializes in moral and legal philosophy. Dr. Smith has published numerous books and articles. Among those books are Judicial Review in an Objective Legal System and The First Amendment, Essays on the Imperative of Intellectual Freedom. Recently, Professor Smith joined the board of directors of the Institute for Justice. And at the end of the stage is Josh Windham, who is a senior attorney at the Institute for Justice, where he litigates nationwide in defense of property rights and economic liberty. He is the co-director of the Institute for Justice's Fourth Amendment project and is currently litigating cases involving warrantless searches of private land, baseless traffic stops, and dragnet camera surveillance. Welcome.
Is this thing on? Oh, it is on. Okay. Can we get some help with the lights here? Being blinded a little bit.
I think they like us.
Oh yeah. Okay, that's fine.
It's their advantage. See,
All right, let's begin. And I think one of the best ways to begin this conversation, because we want to talk about reclaiming the Fourth Amendment. Well, what is there to reclaim? What's going wrong? Let's start with what is the Fourth Amendment? Let's just refresh our memories from high school government, or if you studied it further, or if you've watched TV shows where people throw around the phrases probable cause and unreasonable search and seizure. Let's just go over what the Fourth Amendment is, and then we'll dive in to talk about what's there to reclaim, what's going wrong. And if you'll indulge me, I'm just going to read this out. I'm not going to do it in a British accent. I know someone else did that here to make it more period, but we'll take it from the beginning. The Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, shall not be violated, and no warrants shall issue, but on probable cause supported by oath or affirmation, and particularly describing, I can't see everything, the place to be searched and the persons or things to be seized. Okay. I love reading the Constitution. I think it's so eloquently written. Let's start with this question. We are at a conference about reclaiming the Enlightenment, rebuilding it, saving the Enlightenment. That's a big part of the project of the Ayn Rand Institute by advancing objectivism. I'd like to start with you, Josh. I mean, you could tell us a bit about the genesis of the Fourth Amendment and its connection to the wider Enlightenment project politically and legally.
Yeah, so the Fourth Amendment was a response to a historical problem. I think, Professor Thompson's talk yesterday was a really good introduction to some of this. He talked about general warrants and writs of assistance and the Townshend Act. And in the 1770s and 1780s, and even going back, further than that, there were both British and colonial officials, in England and in the colonies who were using general search authority to invade people's property and their private affairs. And that took two main forms. One form was the use of seditious libel laws, which were laws that basically just made it illegal to criticize the crown, to search people's homes for papers critical of the government. So there were a series of publications in England that criticized the king in various ways. And so king's messengers were sent out with what were called general warrants issued by the Secretary of State that basically gave them unfettered discretion to search any property they wanted to track down the source of the papers critical of the crown. And so there was a big outrage, in England at the time about this and about the fact that people's property was sort of held subject to the unfettered discretion of these king's messengers. Their homes were invaded, their chests were ransacked, their cabinets were torn apart, that kind of thing. The same exact kind of unfettered searches happened in the colonies as well when it came to the enforcement of some of the duties that Professor Thompson was talking about earlier. Looking for goods that had been smuggled into the country without paying the proper taxes and so forth. And so, both in the homeland and in the colonies, you had the use of kind of an unfettered search and seizure power, and that outraged people on both sides of the Atlantic. Now, in terms of its connection to the Enlightenment, I think the Fourth Amendment is an expression of Enlightenment ideals. It's sort of like a classic statement, I think, of some Enlightenment ideals. Two of those being individuals have rights, and the government's duty is to protect those rights. It exists to protect those rights, which means that it has to follow a process tailored to protecting them, a process that is designed in all of its mechanisms, including the enforcement of the law, to ensure that people's rights are being secured at every step of the government performing its duties. And so I think the Fourth Amendment really does that in three key ways. And, we can unpack a lot of that today, but at a high level, I think it's based on the recognition that each individual has a kind of sphere of sovereignty of things that are his and that he controls. And that, his person, his house, his papers, his effects, these are examples of these things. These are some of the paradigm cases of these things, but they're his. They're not the communities, they're not the states. It's his sphere of sovereignty. Number two, it's based on the recognition that human beings require security from state intrusions to some degree, right? Searches and seizures into that sphere. They have a right to be secure, which is that language from the Fourth Amendment that begins the amendment. And then finally, I think the Fourth Amendment recognizes that the government, yes, needs a degree of search and seizure authority, but that authority has to be put under objective control, that it has to be used reasonably and within certain guardrails to ensure the government is actually doing its job, and that our rights aren't being invaded for arbitrary reasons. So that's kind of a high-level overview of where I think the connection is between Enlightenment values and the Fourth Amendment.
Tara, I want to bring you in from a philosophical perspective on the particular value of property rights. So in the text of the amendment, we hear about persons, places, things, their effects. And so maybe you could tell us a bit about the way you think of the value that's being protected here with respect to property.
Well, I think first, let me just say before property per se, I mean, I very much agree with the idea that the Fourth Amendment embodies the spirit of the Enlightenment when it comes to the individual of your life is yours, right? Get off my land, get out of my house, hands off my stuff. This is mine. And if there's a word that I most associate with the Fourth Amendment, it's that word mine, which is a glory. And obviously that shines through a lot of the Constitution and certain other amendments as well of the Bill of Rights. But it's a way of enshrining some stuff, the mineness of certain things. And yeah, if going back to for limiting the power of government, okay, in certain unusual circumstances, you can look at my stuff, but you need a warrant. The very idea, that has to be warranted by an explanation, non-arbitrary, just we'll go take it, give me a good justification for why the government should have more authority now to search your stuff, to search your home and so on, right? So to come back to property then, the persons, houses, papers, and effects, obviously, these things are yours. They're an extension. I mean, your property is an extension of your right to life, your right to lead your life, which involves acquiring property, making things, earning things, creating things, and then you having control over them because they're part of how you make your life and how you lead your life. So one thing I'm sometimes worried about in some discussions of the Fourth Amendment is trying to reduce it to property only in a way that loses, but property is just an expression. Your right to property is an exercise of your right to your life, and that as the broader fundamental.
Can I add one point to that, which is, and can we pull the text back up just so people can see it? So we've got, I mean, I know it, the right of the people to be secure, in their person's houses, papers, and effects against arbitrary searches, right? So there's a security that people are supposed to have against a kind of problem. And I think, just one thing I want to drill down on here is that it's not just that you have some kind of right to the government staying out of your stuff. That's definitely true to some degree, right? But I think this kind of gets at, Rand has this idea that we can't think at the point of a gun. And just to kind of abstract that a little bit and get to, kind of a society level question of the government's use of its power and the kind of power that it wields, we can't really pursue our happiness. We can't really order our lives. We can't really think if we have to tremble in our homes at the idea the government could invade it at any time. Right. So security isn't just about they can't come in except for good reasons. It's about you have to have peace of mind that as a member of a free society, the government can't just come into your property. It can't just search you. It can't just seize your things whenever it feels like doing that. And so security is just as much about the relationship between you and the government as it is about the relationship between the government and your property.
So what I'm hearing in your comments is that there's an affirmation of a positive. So being able to function means being able to function without that fear clouding your life, not only in the extreme cases where the government needs to
Yeah, I
intervene.
mean, just imagine if the government could insert itself into a contract every time you wrote it, or if the government could insert itself into a letter every time you wrote it, right? We wouldn't think we have security in our ability to pursue our happiness, and the same is true of our property.
Well, let's talk about the kind of work that you've been doing, Josh, in litigating these cases. I'd like to just, if you could set the stage for us with what are the kinds of violations of the Fourth Amendment that you're seeing and that you're pursuing in the courts? What is the scale of the problem that you're seeing as well?
Let's see. I think it might help to back up a little bit and just kind of so I help run IJ's Fourth Amendment project. And like, why did we start that project? Like, where did that come from? Why did we feel like there was a need to have a project on the Fourth Amendment at my law firm? And I think one thing we realized was that the Fourth Amendment is can be a powerful shield for not just protecting our property, but for protecting our ability to pursue our happiness and order our affairs and all the rest of it. But when you kind of dig into it, there are these massive holes in the Fourth Amendment's protections that affect huge areas of American life. And so one of the things that we realized was we could step in with a bit of a unique perspective on the Fourth Amendment and try to close a lot of these huge loopholes. And, just to give you a little survey of that and then tell you about some of the cases that I work on, there's something called the open fields doctrine, which is an issue that I work on all over the country. About 100 years ago, the U.S. Supreme Court decided in a Prohibition era case that your land is entitled to zero Fourth Amendment protection. Land is most of the property that people own across the country. It's 1.2 billion acres of private land owned across the country. And according to the U.S. Supreme Court, between 96% and about 100% of all that property is totally unfettered, is totally exposed to unfettered searches by the government. The Fourth Amendment has nothing to say about it. I think that's wildly wrong. And so we're working on that issue. There's something called the third party doctrine, which some of you might have heard about. Amy Peikoff has written a little bit on this, but the third party doctrine says that when you turn over information to a third party, like, I don't know, a health record to a doctor, or Facebook Messenger messages through Facebook, or emails sent through Gmail, you're using a third party vendor to transmit that information. And the idea of the third party doctrine is once you've sent that information over to a third party, you have forfeited all conceivable Fourth Amendment rights in that information or in that data or in that digital property, right? Same is true of even physical letters. There's another big area, business inspections, where the courts will say, employing a really kind of odd form of reasoning, but basically saying, once you've decided to enter a regulated industry, you have sort of entered a place where the government's overseeing it. And so you have watered down or even no Fourth Amendment protections if you're operating a business or working in a regulated industry. Most of our economy is regulated to some degree. And so the point is, pretty much everywhere you look in American life, there are massive loopholes in the Fourth Amendment the Supreme Court has created. And so the goal of our project is to close some of those.
Karen, just yeah, that the Supreme Court has created. It's like the loopholes aren't in the amendment if it's properly understood and applied, but because of the way it's been interpreted for so long, these doctrines that are not protective have really taken hold.
I want to drill in on this concept or this doctrine, the open fields doctrine, because I read a paper you wrote and I was dumbfounded by the way the law actually is practiced. Tell us a bit about how did this doctrine come about? And let me just give you a concrete example just to help us think through what actually is the case right now and what you're trying to fight. So suppose I own a house on 1 acre of property with a field in the back. How much of that is covered? So if I leave a stereo with the stuff on it in my patio, if I leave a tractor or a car in my driveway with stuff in the glove compartment I don't want anyone to see, for example, how much of that is protected? So give us the overview of the open fields doctrine, and then take some example of that scale.
Yeah, so let me start with the text because that's where the U.S. Supreme Court likes to start when talking about this issue. So the Fourth Amendment begins with the people's right to be secure in their persons, houses, papers, and effects. And there was a case in 1924 called Hester versus United States, which involved prohibition. And basically, revenue officers wanted to go onto a private farm to see if somebody was, manufacturing moonshine. This is in the South Carolina mountains. And so they had an anonymous tip. They drove to the Hester farm. They parked, just outside the farm. They walked into a tree grove that he owned. They came up to a fence. They said, "Oh man, we should jump this fence. So they jump the fence. And as soon as they jump the fence, they see somebody near the house hand somebody else a bottle of whiskey. And so the whole case is about whether they were in a lawful place when they made that observation. Did they violate the Fourth Amendment after they had jumped the fence? And the Supreme Court says no in about 2 sentences. I mean, there's really I could basically read you the whole opinion from memory, but the court says open fields, which is a term of art it used to mean land, is not a person, is not a house, it's not a paper, is not an effect. And so it's totally unprotected by the Fourth Amendment, and that's all we need to know. And so the government can do effectively whatever it wants to you in your open fields when it comes to searches and seizures. And the U.S. Supreme Court, in a case called Jones in 2012, put it a bit more pithily. It said, open fields are, quote, of no Fourth Amendment significance. So the idea is, and I gave that 96% figure earlier because to Elan's question, there is an area that is technically protected that you would call land, but the court treats it as part of the home. It's called the curtilage, which is this very esoteric, archaic kind of legal concept. But it basically just means that area right next to your house. So you would think of it as your yard. That receives protection as sort of part of the home. But all of the other land you own, which we've quantified as about 96% of all land in the country, is totally unprotected under the open fields doctrine.
Well, let me stop you there. So suppose I put up a no trespassing sign at the gate of my property. What does that have? What implications does that have for government agents coming in under this doctrine?
Nothing. The U.S. Supreme Court has said that the rather typical, this is me basically quoting, the rather typical presence of fences and no trespassing signs has no bearing on whether they're conducting a search of something protected by the Fourth Amendment. And so it really is true that this is a categorical doctrine, that nothing, you could put up a brick wall at the entrance to your farm, and that wouldn't matter, according to the Supreme Court. And so it's kind of a no holds barred, constitution-free zone when you get right outside that front, back, and side yard area of your property. And, you described being baffled, Elan. I think that it's worth noting that I didn't come out of the womb knowing about this. I didn't come out of law school knowing about this. I learned about it the way you're all learning about it, just in a conversation like this. A colleague of mine had set up we have docket trackers in our job. And so it's, cases going through the federal courts. We might get alerted about cases that are kind of interesting, right? Based on the criteria we enter. And we heard about this case in the Western District of Tennessee, where a guy named Hunter Hollingsworth had discovered a government camera hanging from a tree on his property. And he took it down, and they proceeded to raid his house and accused him of stealing government property. He didn't know whose camera it was. It was just there all of a sudden. And he came to find out that state wildlife officers had entered his property without a warrant and put a camera there to spy on him to see if he was violating hunting laws. And they didn't have a warrant. They didn't have probable cause. They didn't have his consent. He didn't even know it was a government camera until they accused him of stealing government property. He sued under the Fourth Amendment in federal court. And the court basically said, open fields doctrine resolves this issue. Nothing to see here. If you want to go try to sue in state court and pursue state constitutional remedies, you can do that. But the open fields doctrine resolves this. And the court gave a really pithy explanation of how that works. It said, your property is basically like a public park as far as the Constitution is concerned. So my reaction to that was, this is America, damn it. That doesn't seem very right. And so I've spent the last 5 years going down a rabbit hole of basically going to war against this doctrine.
Yeah, I mean, you can't believe some of these things. Like, you wouldn't have believed them when you hear them your first, right? This is the U.S. I just want to point out, implicit in what Josh has said in the last few minutes, notice there is usually a rationale. Well, why would the government do this? To enforce the hunting laws, to enforce prohibition, campaign finance regulation. Like, the more we regulate, hey, we have to make sure people are complying. Thus, we, the government, have the authority to invade your backyard or your hunting or whatever it might be. But the usual justification is we need to make sure that we're enforcing the law, whether it be regulatory law or some other kinds of laws. But that's usually...
So this question might throw us off, and tell me if it's not the right question to ask at this point, but I want to understand this doctrine. So if I'm driving down the street and the police officer stops me, in order to search my vehicle, I understand they need probable cause. Am I right so far?
That's right. Yeah.
Okay. If I so far, if I'm driving, or let's say I park the car in the field outside my house, outside the curtilage, which is a small halo of property that's considered within the Fourth Amendment protection, and they want to search that car that's parked in that field outside my house, they can do that without probable cause, or they still need that?
So this is a question that came up in a case called Collins versus Virginia. And I think it's an unresolved question actually in the law because the open fields doctrine has never been applied to seizures. And, physically tampering with property is often construed as a seizure as well as a search. And so there's a question of, what to do with a car would be in effect, right, under the Fourth Amendment's plain text. And so the open fields doctrine has always sort of been about, at its most literal, officials using their boots to walk onto people's property and look at things, right? From a place that they don't have a lawful right to be, but the U.S. Supreme Court says they do have a lawful right to be. If they're tampering with things on the property, if they're touching your effects on the property, that might change the constitutional analysis. I think the government would say it doesn't, but I think it might.
So you brought up this point just now, Tara, about how the more there are these regulations, like prohibition is a good example, the more we have government intruding into our lives. I'm interested in your perspective on that, as to just that dynamic going on, and does that fit into your interest in the Fourth Amendment, or is it peripheral?
Um, hmm. It's not what generated my interest in it, but you certainly find it. That is government, primarily with regulations, and then, well, we have to enforce it. But are you just interested in my
How did you get
how
into?
did I get interested in this? I'm not sure exactly. Um, I guess so. To remove it from just the Fourth Amendment, I'm interested in privacy, and that's often associated with the Fourth Amendment, but with no particular amendment, but with a lot of constitutional related court decisions like Roe v. Wade. I mean, there are many things that people will put in the privacy bucket, though the word privacy does not appear in the Constitution. And when you look for a home for it, you'll have some uh, Supreme Court opinion saying, well, it's kind of in the First and the Ninth and the Fourth and the 14th and various things. So I just wanted to clarify, people talk about a right to privacy. Is there really such a right? What other rights would that be related to or an exercise of? But so it had been a question in the back of my mind. There's this concept that I think we're fuzzy about legally, but not only legally. Just what is privacy? People often, so the old, I know it when I see it when it comes to obscenity. I feel like I know it when my privacy is taken away, and I'll be very indignant about violations of privacy. At the same time, starting, I don't know, 15 or 20 years ago, with Facebook and everything, you had a lot of complaints about people aren't being private enough and they're sharing everything online and too much information. So I just found a fuzzy area that I wanted to clean up in my own understanding. And that led me into more careful examination. And I've been working on this lately of some of the legal issues and the Fourth Amendment in particular. But I remain extremely interested, and I'm writing something right now short, but just on the value of being private. So apart from the law, leave aside the law, suppose the law is treating us exactly as it should, respecting our rights to privacy, respecting the Fourth Amendment and everything. Is there value in being relatively private or private about certain things? What is that value? I'm working on a paper now. Maybe I'll give you a lecture someday on it. But I think it's related to how one relates to one's values. Because privacy is about who you share your life with, who you share information with, who you do things with. Others are, associating with others in certain ways. We do certain things in private. Breaking bread can be breaking bread with somebody is a somewhat intimate, and, if you understand, like there are things we do together that I should have control over. Freedom of association. So, if you want to get back to the rights issue, property association, etc. But how should we treat our associations with others, what we share, what we divulge, and all of that? I think, while I think there's room for taste in that area, I also think there's room for objectivity about how much your values mean to me that should govern that. So I'm working on the value of being private as a reflection of integrity, self-respect, and things like that.
I could just add that I think that the fact that you're working on this is actually It's refreshing to me because privacy in the Fourth Amendment context is kind of a chimerical concept, and it sounds like your observation is that that's true across the law and across like social conversation about the concept as well. I mean, just to give maybe the audience a little overview of how privacy comes into the Fourth Amendment, because it's not, you mentioned it doesn't show up in the text. It's not obvious where that comes from. So, um, if you think back to like just founding era searches of people's property under general warrants, I mean, the government didn't have the ability to invade our privacy without physically intruding into our stuff. I mean, like pretty much the only way to figure out, what somebody was thinking was to go break into their house and read their letters, for example, right? Unless they shared it publicly. So, I mean, private affairs were pretty much bound up with property at the founding in most important ways. And that's really changed with, the digital age. And we might get into some of that later. But back then, it was a little bit easier to see the relationship between property and privacy and to think of them as kind of the same. Um, and so, at I guess over the first like 150 years of American history, there weren't a lot of Fourth Amendment cases, but the early ones, like this Hester one I talked about from the 1920s and a few others, they were very heavy on thinking of the Fourth Amendment as reducible to the words in the amendment read as narrowly as possible. This is kind of strict textualism. And there was a failure to appreciate kind of context and to think more abstractly about the Fourth Amendment or to think more in principle about it. It's just, what do the words mean, literally speaking, read as narrowly as possible? That's all we have to know. And there was a reaction to this in the 1960s, where you had the government starting to use new technologies to invade people's private affairs, private spheres, in ways that weren't traditional, like things like wiretapping, right? Things like placing a listening device onto a phone booth so that when somebody was having a conversation, they could hear them. Maybe there's no invasion of property, strictly speaking, but there is an intrusion to something that property traditionally would protect. And so the court in the 1960s, in a case called Katz, kind of invented this reasonable expectation of privacy sea change in Fourth Amendment law, where it said, actually, the question when we're assessing whether a Fourth Amendment search has occurred is not whether they've physically intruded into something that you own, but instead whether they've invaded an expectation of privacy that society would consider reasonable. Now, there are all sorts of problems with that as a standard for enforcing constitutional rights, but that is where privacy comes from in Fourth Amendment law. And things have kind of waxed and waned on that front over the past, 50, 60 years. But the thing that I want to kind of drill down on is just that way of thinking about privacy and that way of articulating the standard for it is non-objective. And it ends up being a double-edged sword in the Fourth Amendment context. It both enhances some of the rights that we have, but also can be used to reduce the rights we have. If society wouldn't deem Tara's expectation of privacy reasonable in any given context, or if the court thinks that society wouldn't deem it reasonable, that's enough to vanish your Fourth Amendment rights.
I want to come back to the interpretation of the text because I know that's important. You've written about that and you have perspective on this issue as well. Before we do that, I want to hear about maybe one or two more cases that you're actively working on. Give us sort of the details, the situation.
Okay. Let's see here. So, setting aside kind of a series of cases I have about open field searches and trying to protect those under state constitutions, I'll just give a couple more examples. So, I have a case that I litigated out in Ohio. It ended pretty quickly after the government gave up, but I represented a man named Jeremy Bennett, who was a taxidermist. He had a taxidermy studio that he had built on his property, and local officials had authority under a state regulation to go inspect taxidermy records. And there was an inspector in his area that for the longest time treated him really nicely, would call him in advance and say, "Oh, it's time for your inspection," and then he would walk in when they could schedule a mutually agreeable time. And he would say, "Oh, show me your papers." And they would stay at the front desk. And it was all very cordial and nice, not very intrusive. Um, then a new inspector got hired for that role. And he was young and ambitious in the worst kind of way and decided that he wanted to make Jeremy's life sort of a living hell. So he would show up at his shop whenever he felt like showing up. He would walk past the front desk without talking to him. He would roam around, like open his cupboards, pull meat out of freezers, look in ceiling tiles. And Jeremy would ask him, "Can I help you find something?" And he would say, "Everybody does something wrong. We just have to know what you did. And I'll let you know when I find it." So he was being treated as sort of a presumptive criminal, even though Jeremy hadn't done anything wrong. And this was all authorized by a state regulation that allowed these officials to go in and search without a warrant. And so it all came to a head when, at the height of deer processing season, and Jeremy also did deer processing, things were really crazy. The inspector came by, and he said, I finished, inspecting your deer processing area. It all looks good. I want to go search the taxidermy studio now." And Jeremy said, "You know what? That isn't open for 2 weeks. And if I asked anybody in this room, what does your bedroom look like right now? You would probably say it's not very clean, right? Or at least I would say that. Maybe I'm projecting onto you. But Jeremy, hadn't been to his taxidermy studio in a few months. It wasn't season. It wasn't ready yet. And he said, "You know what? Can you come back in 2 weeks when it's open? You can have a look around." And the guy said, "Sure." So he left. And Jeremy gets a letter in the mail that says he's being criminally prosecuted for refusing a warrantless inspection of his property. Now, whether he refused it or not isn't really the issue, right? He had every right to refuse it, even if he had. And the whole case was about, can the government have a regulation on the books that authorizes these kind of unconditional warrantless inspections of people's property? After we sued, they gave up pretty quickly. But the point is, like, people like Jeremy, who have property for a reason, who are using their property for productive purposes, who are law-abiding, who are just trying to kind of pursue their happiness in their own way in their own private sphere, shouldn't be treated like that, shouldn't be treated like criminals. And the Fourth Amendment exists to put a shield between people like Jeremy and people like that official. So that's one example. This is the business inspection context. Another is that I filed a case last year in the city of Norfolk. This is very different than the ones we've talked about so far. So the city has decided to put up a network of automated license plate readers all over town. So everywhere you drive, your movements are being recorded 24/7, 365. And that information is stored in a database, and they can create traceable maps of everywhere you've driven. And so if you just think through what that means, it means that the government has a repository of everywhere everybody in this room has driven if you happen to live in Norfolk. Now, that strikes me as, you could use dystopian, Orwellian. I mean, there's lots of words we could use for that, but I just think it's creepy. Um, that's not a term of art. That's just, my gut reaction to it, but it's capturing something real, which is, like, I was getting at this issue of security earlier, and the power dynamic we have with the government, and the need for the government to have objective reasons rooted in the law for investigating us, for intruding into our private lives. And it's true. When we're walking out in public, we don't typically expect the same kind of privacy that we have in our homes. But I don't think of it as a privacy issue. I think of it as a security issue. If a government official carrying a gun were to do exactly what these cameras do by just following you around all the time, you would feel threatened by that. And rightly so. You can't live your life if the government is always watching you, ready to pounce on the smallest activity. And so what we're doing is saying this whole system of setting up a surveillance state in the city of Norfolk violates the Fourth Amendment.
It makes me think of the systems that are in place in China where people are monitored all the time. I want to come to the more technologically advanced situations in the digital space in a minute. I want to tell everyone in the audience, we'll be taking questions in about 10, 15 minutes. If you're thinking of questions, write them down or keep them in mind. We'll open up the mic in a little while. I want to come back to this issue of interpreting the text of the Fourth Amendment, because you've said this is part of the legal landscape. And you've written on this, at least in the one paper I've read where you attack that. So tell us about your view of how the text is understood, what you think is wrong with it. And I'm interested in your perspective on this as well, Tara.
Yeah, I think that there are kind of two problems right now in Fourth Amendment law. One is that you had this initial period of taking the text and reading it as narrowly as possible and dropping all other context that might inform the meaning of the words. And I think there's a difference between, like, the dictionary definitions of words in isolation, whether today or in 1776 or in 1789, and what the words mean. Like, meaning is context dependent. And I get some of that from Tara's book. It helped inform the way I think about the Fourth Amendment and other constitutional provisions. But the point is, individual rights are not these, like, concrete little snippets of meaning on paper, right? They're principles, they sweep broadly, they're designed to do work in particular contexts. And if you think about the general warrants that inspired the Fourth Amendment, I don't think you can capture the problem that the Fourth Amendment was designed to solve and the threat that general warrants posed to Americans at the founding by just saying, okay, let's home in on 5 of the Fourth Amendment's words, persons, houses, papers, and effects, and treat that as an exhaustive list of everything that it means. I think that's just kind of missing the point. And we know that it's missing the point for a number of reasons. One, the Ninth Amendment tells us not to do that. In fact, the Ninth Amendment is in the Constitution as a rule of construction to tell us not to read the Constitution this exact way, and yet courts like to do it anyway. Part of that is dropping the context in which the amendment was adopted. But the other issue I want to talk about, not just the text, but is this kind of cat's case and the privacy issue, because it's a legitimate reaction to the way the court was narrowly thinking about the Fourth Amendment in the early 20th century to say, surely something is missed by this way of reading the Constitution. Surely this is too narrow. Surely we're not kind of getting at what this is all about and what it is designed to do for Americans. And so I think while we can criticize the cat's case and the privacy test that developed out of it, I think it was a legitimate reaction to a real problem.
Yeah, I guess mostly I want to agree with you that it's meaning is contextual, and you cannot take 2 words or 1 word or any 1 word in isolation from the larger amendment, the larger Constitution, the principles animating that Constitution. And that is so often what interpreters of the law do. And now, obviously, for various reasons, you need to focus on certain points of the text, but you can only understand what they mean by understanding the animating spirit and principles behind them. You have that nice example that you've used before in your writing, the first grade. Yeah.
Oh, yeah.
What you want to?
Yeah, sure, that's fine. So I thought you were talking about the First Amendment, but I'll give that one too in a second. So my wife was a fourth grade teacher for about 10 years, and it's funny. So to back up for a second, I was just complaining to her one day about the Fourth Amendment, as one does, and she's there kind of rolling her eyes at me, and I'm talking about the open fields thing, which is a lot of my cases are about that, and she just sort of stopped and said, "That's not how it would work in a classroom." I was like, "What do you mean? Yeah, tell me more." And she said, "If I had a list of classroom rules on the wall, like the kids, no one would read the rules the way you're describing the court reading the Fourth Amendment." And so what she was saying was every year, and she kind of dove into this, she puts a list of classroom rules up on the wall. And the students all get together and they all come up with the rules. And the goal is let's create a productive learning environment this year. Right? Let's come up with some rules that will create a productive learning environment for everybody. And one of the rules that every year shows up because people get it, they know what it means, is keep your hands to yourself. Now, if we read that rule literally and we drop all possible context, like, I don't know, can I hug Tara? Can I give Tara a high five in class? That seems like it would be forbidden by the rule, but I could kick her because feet aren't hands, right? And it just like you're laughing because it's preposterous. And I think the same thing about the Fourth Amendment. Like, we don't read the Fourth Amendment this way. And it's designed to sweep much more broadly than a classroom rule is. Now, just to give the example of the First Amendment, which I was getting at for a second, the courts get this about the First Amendment. The First Amendment prohibits the government from, censoring speech and press. Okay. Well, is a handwritten letter speech? You're not uttering words out of your mouth. Is it press? You're not publishing it. If I send Tara a letter, it's just a written communication, but it's neither speech nor press if we take those words as literally as possible, right? But the point is, obviously, my handwritten letter to Tara is the sort of thing the Fourth Amendment is supposed to protect. And we get there not by reading words as narrowly as possible and not by exhuming in some kind of archaeological way their historical meaning to one group of people, but instead by thinking of principle about what this provision is designed to do.
The one thing, so I was going to give some First Amendment examples, but I won't do that. But I will say, and this is a rather fine point I'm making now, a fine point. But I think it's a mistake to even say, well, the literal meaning of the words is such and such. But if meaning is contextual, then any of these words isolated from context, it's not that this is their the literal meaning of a search or a seizure. There ain't no meaning there without context. And I think this is a mistake that some of the originalists often make and certain textualists make.
Yes, and just to tie in how, because your original question, Alon, was how I make sense of the text and some of how I think that through. So part of the context that I think matters here, if we go, I mean, you don't have to pull the text up again, but notice that the Fourth Amendment's text doesn't say warrants are required. It says unreasonable searches are not allowed in certain forms, and that there are requirements for a valid warrant. No warrant shall issue but upon, there you go, but upon probable cause, supported by oath or affirmation. I mean, these are a series of guardrails that constrain the warrant power, but nothing in there says warrants are required. So how do we get from that to a rule that says warrants are presumptively required, which is kind of the rule that applies in most of Fourth Amendment law? And we get there by recognizing that times have changed. So in 1776 or 1789, in this like founding era period, there was no real law enforcement apparatus. The way that it worked was that the government could search your property if a complaint was initiated by a complainant, right? So if I think Tara stole something from me, I would go to a justice of the peace and I would swear out, oath or affirmation, right? I would swear out a complaint that said, I think Tara, for the following reasons, stole my shovel. Okay. And if the judge reviewing that application thought there was probable cause to think that Tara, in fact, based on my oath, right, stole my shovel, then, and only then, the law enforcement apparatus that existed would be triggered, would be activated, and officials could go pursuant to the warrant power and search the property for the shovel. And I just give that as the example because it's not really the way it works today, right? We have like massive law enforcement bureaucracies. There's sort of an understanding that police have much more search and seizure power today than they might have had at the founding. Whether that's legitimate or not, the point is, in the context the Fourth Amendment was adopted, controlling the warrant was controlling the search power, right? And so the requirements for a valid warrant that are baked into the Fourth Amendment are effectively the requirements for valid searches the framers had in mind. And that's an important part of the context if we're trying to understand what is this provision doing. And it would be missing the point to say, oh, let's read the text literally. It doesn't require warrants, therefore warrantless searches are fine. But if they issue warrants, they have to follow certain, doesn't make any sense.
So let's pick up on that thread that you brought up. Things have changed from when this was first written and the kind of technology that's available to government and police in particular. We're now in a world saturated with technology and information, and search and seizure cannot be unreasonable. And what does that look like when we have so much data? So we have not only who even has a landline anymore, right? But everyone has a phone almost, and we have internet traffic, so much of that happening. And you mentioned tracking license plate. We don't need to track license plate. Our phones are GPS trackers. There's so much data about what we do and what we say. What are some of the concerns that arise in your thinking around this with so much more activity that's digital?
I think that one of the things that comes up a lot in this context is that the government has access to a lot more information about us. But the thing to unpack there is how did it acquire that information, right? Because I mean, it strikes me as, I mean, just think of Amazon. Like Amazon has a lot of information about me. I click yes to all the cookies. Okay. My concern for my privacy, at least when it comes to companies having my information so they can advertise to me, is pretty low because I want good ads. Like give me the stuff that I want, right? Don't give me the stuff that I don't want. And so I'm fine with that kind of tracking of my information. Other people are not. Other people have a much more hygiene about that, right? They care more about whether my dad clicks no to all the cookies. Okay, when he opens his laptop, he closes that camera, even if, even if he's not on a call. And the point is, some people are just more conscious about what others know about them. I have a pretty high degree of tolerance for people knowing facts about me. Others don't. Like others might be more kind of a hermit, and that's totally fine. Um, I don't know, Tara, if you have thoughts on whether those things are kind of optional values, but setting that aside, I think the question for the government is, how did they acquire the information about us? Was it coercive? Did they purchase bulk data from a company, right? And is that valid or not? I think there's a lot of people who come to us and ask us to sue when the government purchases databases from private companies and then uses that information. I'm not so sure that's a huge constitutional problem. Maybe it is, right? Maybe the government doesn't have a legitimate interest in sweeping up from private markets lots of data about us, but I'm not sure that it's a constitutional violation. I have to think it through more. But these are the kinds of things we would unpack because, today so much information about us is easily collected en masse in bulk. And the question for me is really, how did the government acquire it and what is it doing with it?
Yeah, so I just think we have to have a very clear dividing line between what companies can acquire and what the government may acquire, right? So, right, it's fine, as you say, if your father has different tastes in how much privacy he's willing to give up, vis-a-vis different companies than you do, right? We all do, and that's fine because that's a matter of our private agreements. It's worth the convenience to me to just check certain things, and I know with this company that means that company is going to get it. But hey, that's an agreement that I agree to, even if people love to say, "Well, nobody reads the print." Well, read it because you're taking. I mean, if or don't read it, but understand it's your choice, right? Okay. Um, but yeah, I mean, the government, everything the government does is via coercion. So why does it need that information? Not only how did it get it and what is it going to do with it, which are important pieces, I think, of why we worry about the government having so much information, but why does it even have all that information in the first place? Like, what does the government need to know about people? And I think, the sad thing is, and this a little bit comes back to your Ohio example, the taxidermist and the new guy on the block, the new warden on the block coming. It's like, well, everybody's guilty of something. We just have to find out what. I'm not sure what language to use for that despicable view. I mean, it is the reverse of the individualist Enlightenment view. Your life is yours. The presumption of innocence, just the presumption of you're a human being going about your life. I, the government, have if and when I have no reason to think you in particular are a menace, you're likely to violate these laws, you're likely to infringe on the rights of right. It's in those kinds of circumstances when there's probable cause of thinking that we are justified. But other than that, what you do is your business. If there's no reason to think, in those circumstances where there's no reason to think that what you're doing is interfering with the rights of others or breaking our, just laws and so on, then they shouldn't have the information in the first place. So that's what worries me just about the government acquiring all this information. And then, as you well know from some of your own cases with, what they get on the babies and keep for 23 years, um, the more information the government has, the more they might find some way of making it look bad for somebody and not just justifying further infringements on the person's freedom and so on. Yeah.
The word that came to my mind when I heard you describe that was this is what authoritarian regimes do. Everyone is guilty. We just have to figure out what we need to make it stick, or we may make it look as if we've gone through a process of law. And so there's a way in which there is law, but it's not being enforced. It's not even remotely objective.
Yeah, I mean, if you look back at some of the, Professor Thompson mentioned James Otis yesterday, and Otis was one of the big champions of fighting back against general warrants in the founding era. But, Otis and others, their big concern about this was far more about the fact that arbitrary power was wielded at all than about any specific instance of like that person's house was invaded or that person's house. It wasn't like there was one home invasion that really set them off. It was really, our people are living under a system right now where, depending on the whims of the officials who hold this power, any property could be invaded at any time. And that's the problem. The point of the Fourth Amendment is to put that kind of discretionary power under a degree of objective control, to put guardrails around it so that, the malice or caprice or prejudice of somebody enforcing the law, isn't really animating what they're doing.
So we're going to open up for questions. And as people come up to the mic, which is situated over that side of the room, welcome your questions. I want to ask you guys one more question. We'll take some audience questions and we'll come back to the panel to close the reflections. I think this is implied in everything and maybe even fully stated, but it's worth putting it on the record. So would you say to the criticism that in your work, you're anti-law enforcement?
Yeah, I think, at the most basic level, the enforcement of the law requires compliance with the fundamental law of the land, the Constitution, right? So I don't think that law enforcement can be conceptually coherent without an appreciation for the fact that the Constitution has to provide the guardrails around legitimate law enforcement. So I like to think of it as, I'm pro police officer. I'm totally fine with the enforcement of all the laws in the cases I litigate. It's not like I'm concerned with the laws themselves. It's more that I'm concerned with the way the laws are enforced. And so my position in all these cases is enforce the law all you want. I encourage you to do that. Just follow a constitutional process for enforcing them, because none of my cases say the government can't search you. None of my cases say the government can't seize your things. Those are legitimate parts of the government's authority. It has to enforce the laws. It has to catch the bad guys, right? That's part of its job. It just has to follow a constitutional process for doing that. And the Fourth Amendment, by design, makes it harder to do that. It's baked into the system that unfettered power is going to be less, quote unquote, efficient than fettered power.
All right, well, let's turn to questions from you in the audience. One guide for as we go into this, please try to make your question as succinct as possible. And if you have a follow-up, just rejoin the line. We'll try to get through them as quickly as possible. And a guide for our panelists, I don't think this will be an issue in this group, but let's make your responses succinct too. And if there are follow-ups, people can come back. All right, let's begin.
Thank you for the discussion. I have a question for Tara. The privacy question, do you have a definition, a workable thing? I'm sure it's not done yet, but something that is we could use also in discussions when talking to.
Well, I guess it depends on what you want a definition of. I mean, because there are a lot of different related concepts here. There's just what is privacy. There's what is a right to privacy. What
In
is
a legal context.
value of privacy. Oh, well, the legal, I should really defer to Josh on the legal. But because again, well, I'll say this is not legal so much as just political philosophy. I see the right to privacy as, if you want to use that language, the right to privacy, it's derivative from the right to life. And in the same way that we speak of the right to free speech or freedom of religion or freedom of trade or the right to travel, like we speak of these rights, they're really all simply particular ways of using your right to your life, your right to liberty, your right to pursue happiness. Okay. So I don't think the right to privacy is sui generis or has its own independent foundation, but it is one way of exercising your right to life is to be relatively private, to keep certain property to oneself or just to those one chooses, to associate with others. Again, I mentioned earlier, I think it's closely related to what we sometimes call the right to freedom of association or the right to property. So in terms of the right, that's how I understand it, at least at the political philosophy level, which is not more technical, legal. And then notice too, like even when we speak of privacy, we could be speaking of the condition. He's in private. He's in the private car of the train. He's in a private dormitory room, or the conversation is in private. It's a condition of being relatively secluded from other people. Though we also speak of the right to private. I'm sorry. So there's privacy in that sense. There's privacy in the sense that he's a private person. We sometimes characterize a person's disposition to share things with others as he's more or less private on the spectrum. And we sometimes mean the right to privacy. So there's a lot of you have to clarify in the beginning what exactly you're then trying to understand better.
Just to add one point to that, I mean, to the extent that privacy is a right, I think it's worth noting that there are definitely bounds that can't cross. So, I mean, I forget, there was a podcast, error I had out recently talking about, protests and like, do you have a right to speak on somebody else's property or even government property? And that's, it's a question that I think might have an unintuitive answer for a lot of Americans. But, privacy is a thing that is sort of emergent in a lot of ways. It's a condition of the way that you order your life. And so, I don't have a right to the means of having privacy, right? I mean, I could have privacy in my home, but I have no right to a home. Right. And so I think it's a kind of a thorny question because it's used in so many different ways.
Can I add one thing here actually about government? So much for being succinct. With a lot of clamor, I mean, there has been a lot of popular clamor in recent years for the government to do things to protect our privacy, in particular from those big bad corporations who are taking it all. But as people realize, gee, because we all have these smartphones and we're so trackable and everything, we need our privacy protected. And many, many states have passed laws that put all sorts of restrictions on trade, on the contracts, the agreements people would make in the name of, we, the government, are protecting your privacy. Don't protect my privacy, protect my right to privacy. My right to make the decisions and contracts and agreements that I choose to. But what we've got now is a kind of privacy paternalism. Oh, the government will be the good guy and look after your privacy. We'll figure out how much privacy you should have, and your father maybe wants too much. We, the government, know best, so we'll protect your privacy. Okay, get out of my privacy. Give me the right to be as private or as open as I choose to be with, willingly with others and so on. So there's work to do.
That made it very clear. Thank you very much.
Thanks.
Thank you for the talk. My question is to Josh. So, in your case, what exactly are the standards for public surveillance? For example, I know in New York, you can't have a police officer on every subway or at every traffic light. So instead, there's a lot of public police cameras, and I don't know if there's anything wrong with that.
So I guess there's two answers to give, and I'll give you the first one, which is the legal answer. This is where the Supreme Court is currently at. So the Supreme Court, in a case called Carpenter in 2018, announced that when we're talking about people's movements in public, you don't give up all your right to privacy when you're in public. Now, whether that's the right way to think about the Fourth Amendment at all is a separate question. But for my purposes, all that really matters is, does the Fourth Amendment apply at all? Right? Do the substantive requirements of warrant and reasonableness, do those kick in? And what the court said is, you do have some right to privacy in the public. And when the government is tracking what it called the whole of your physical movements, in other words, like it has a historical repository of the places you've been and access to that repository of the places you've been, that violates an expectation of privacy that the court says society would deem reasonable. And part of how it got there is it through analogy, right? Nobody, no officer at the founding would have had the power to just stalk you 24/7. In fact, people don't have the power to stalk you 24/7. That's called a tort, right? And so, part of it is, I think that New York system, if it's sort of a panopticon of surveillance that can track everywhere you've been and create a record of that, I think that presents serious Fourth Amendment problems. But just setting aside that whole framework, the way that I think of it is just, you have a right to be secure in your person, and you can't possibly be secure in your person if the government is watching you 24/7, 365.
Yes.
There's a question from online.
Yeah. Let's take that one.
Is there any case wending its way through the works to the Supreme Court that will readdress the open fields decision?
No, and if there were, it would come from me. Probably. And I say that not out of to brag, but just because nobody's working on this issue. I mean, it's considered a sort of dead issue right now. It's been black letter law for 101 years that the police can do this to you. No, there's no real incentive outside of the public interest space to push back on that effort. Um, I would say that, our long-term plan is to spend a number of years working in the state courts, working on state constitutions, getting states to reject the open fields doctrine as a matter of state constitutional law. And we're having a lot of success on that front right now. And, 10, 20, 30 years from now, when the time is right, it depends on the court, depends on who's on the court, take the issue back to where it belongs and finally get that decision overturned. That's one of the goals of my career. Hopefully I achieve it. But, we've got a lot of years to go.
Can I just add on that? But organizations like the Institute for Justice, Pacific Legal Foundation, and others, they have success this way. Like, they started something where, wow, all the precedent is against us. This has been so entrenched. We're the only people bringing this kind of case. And they chip away. I mean, there has been, think about civil forfeiture, for instance. There have been other examples like these guys have effects. They get court rulings, here and there and in the state courts, and they get more attention to these issues. And some people realize how right-minded some of these ideas are. And so I think we'll be hearing more about the Fourth Amendment thanks to the work of people like Josh.
Thank you. Let's come back to the floor.
Can justice still be served when the Fourth Amendment is violated?
So just to ask a clarifying question, are you getting at the issue of suppression of evidence, or are you just asking a broader question?
I was thinking about the O.J. Simpson trial. How the Fourth Amendment was violated, and then you had the O.J. being free when.
Okay. So, so there's a couple issues here, and I'll be very honest with you. I don't know a ton about the OJ trial. It's not a thing that I consume or consumed. I wasn't around. But I will say, the most common criticism of Fourth Amendment doctrine today coming from the kind of originalist right, and Justice Thomas has been leading this kind of vanguard, is that the rule that when the government acquires evidence about you, when it violates the Fourth Amendment, and then uses that evidence to prosecute you, has to be thrown out of court. It's called the suppression principle, right? That rule, according to Justice Thomas, has no legitimate originalist foundation. It's not based on the text history or tradition of the Constitution. I disagree with that. I think the exclusionary rule that keeps unlawfully obtained evidence out of court is a good and legitimate rule. But setting that aside, because the most common criticism of Fourth Amendment doctrine there is that you're letting criminals go free even though the government has, so it's two wrongs don't make a right type of logic. I think the broader concern, though, is that we can't have a culture, a legal culture, a law enforcement culture that allows the government to systematically violate people's rights and get away with it. If it can violate criminals' rights, it can violate innocent people's rights. And that's the real problem.
Next question.
F.A. Hayek, especially in his book Fatal Conceit, hammers the point that you cannot devise a social order rationally. You need to wait for it to arise spontaneously, organically. And the founding fathers seem to differ because they founded the United States as a very self-aware, very philosophical project. And this is like a paradigm that I think you also represent in this panel by philosophically discussing law and what it means and what it should be like. So basically, my question is, do you think F.A. Hayek's idea that no, it's only the spontaneous order you cannot have, does it hold any water at all, or do you think it's completely false?
Not really sure how to respond. I'll say my understanding is that the time of the founding, the people were behind the ideas that were written into the Constitution and so on. Like they're pretty much on the same page. It wasn't like, well, the people are from the ground up. You had this, and then these rationalists, philosopher inventors and thinkers like Jefferson and Madison imposed these ideas on us. Now, what I think is interesting to bring us to today is the people we need to, and this is the role of philosophy again, like we need to understand individualism and to give a goddamn about saying his life is his. My life is mine. But people don't have, really, that has eroded over time. The appreciation of your life is yours. You're not a cog in the wheel. But this is collectivism, collectivism has risen in the last few hundred years in this country, and individualism has fallen. And that's why, oh yeah, government, you tell me how private to be. You tell me how this, that, or the other thing to be. Take care. So, we, the people, need to reclaim the idea. We need to first start understanding again. Yeah, his life is his. Anyway, don't let me go on about.
So, and this is not me coming at this from necessarily like some kind of doctrinal philosophical perspective, but the phrase spontaneous order strikes me as a bit of a misconception of what order is, because order isn't an accident, right? It develops as a result of human beings interacting with one another, pursuing value and trading. And there have to be rules in place that set the parameters for the trade, right? That make it possible to pursue value in the first place. And so, if we have, this is why the Fourth Amendment is so important to me, right? It's not just a rule that says the government can't come into my stuff, although that's often important. It's a rule that gives us the peace of mind that we need to order our lives and pursue our happiness, knowing that we won't be invaded at any time. And that is the kind of social condition you need to have any degree of order that's meaningful and valuable.
Good. Thank you.
So you're talking about how textualists apply the principle that the expression of one thing excludes another. That is, since the Fourth Amendment talks about persons, houses, papers, and effects, then it doesn't apply to anything else like land. And is it more of an issue of the writing of the Fourth Amendment that it doesn't state and other forms of something, or is the primary fault on the judges misinterpreting the text of the Fourth Amendment?
If I could go back in time and put myself in John Adams and James Madison's shoes, would I write it differently? I don't know. I'm not as smart as them, so maybe they had it right. I'm not one to criticize, necessarily the way the Constitution was written. Could it have been written more clearly? Could it have been written in a way that was more conducive to courts understanding the principles involved? Probably, right, in a vacuum. I do think that the onus has to be, though, given that we have the text we have, on the courts to get this right and to think about it the right way. And I just think that one of the biggest problems in judicial review right now, and the way that courts are doing constitutional law, is that they see it as a project of archaeology and not as a project of understanding the principles underlying the country and the Constitution.
Yeah, no, I think the archaeology is a good way of putting it. You can't make any text idiot proof. And you can't, no, but I don't mean that, sorry, like, you cannot write down everything, or meaning, you can't, in a sense, outsource to words an intelligent understanding of what those words mean. So it's not like, oh, if they wrote it a little more precisely, or if they added this, and this. It's still a conceptual project to understand the language of laws, the language of constitutional provisions. It's a conceptual project, and you can put the conceptual understanding on the page.
And just to give one more example of that, I mean, like I mentioned earlier that the courts are pretty good on the First Amendment. Like they don't make some of these mistakes that they make with the Fourth Amendment with the First. But think of something like obscenity, right? Now, the court treats obscenity as it's not in the Constitution. It's not written there. We don't have an obscenity exception to the word speech in the First Amendment. It doesn't show up there. So where does it come from? And the court just sort of says, well, historically, obscenity everybody knew it was an exception to the. It's not obvious to me. Now, maybe it's true. Maybe there are reasons why it should be an exception to the concept of speech protected by the First Amendment, but it's not obvious that it is. And it requires conceptual work to figure out whether it is.
And this goes back just to the archaeology comment. And again, I think this is where a lot of the originalists go astray, that the original meaning is not the objective meaning. And if there was a misunderstanding of a concept, we should not perpetuate the misunderstanding. We should try to figure out what is the objective meaning of the words understood in context, animated by the larger underlying principles and so on. And some of this I do talk about in my book on judicial review. Like there's some chapters there that really
I've read this.
go into the details. Good.
Thank you.
Thank you.
How are law journals and legal societies recommending judges an effective mean to bring a presumption of liberty to future decisions?
I don't think they are. Is the question, how could they do it?
Well, I know they've been effective to do it in the other way. Like there's been a lot of work. I mean, one of the reasons we got, I think, the Roe v. Wade decision that we had was a work done by the religious legal thinkers over time, through their societies, through their papers. Like this panel was about, the project for reclaiming liberty. Well, I think you're going to need to build an institution. Are those good things to start with? And what has been done with that?
I see what you're asking. Yeah. So I think, you're right that both Roe and overturning Roe, a lot of the biggest moments in our legal history were the product of intellectual movements, right? They were not the product of accident. They were not the product of the whims of particular courts. They were the product of decades of effort by, law professors and like public interest lawyers and even private lawyers who were ideologically aligned. And so, on the question of how we can go to a presumption of liberty kind of mindset, I mean, if you kind of step into the public interest legal space that I'm in, I think we pursue avenues on like every front, right? So we've got in-court litigation. I'm both litigating cases and writing law review articles and speaking publicly. I'm pretty much doing every form of advocacy I could think of to try to push my issue forward to both change the culture and change the law. I think that's the only way to do it. And I think the downside here is that a lot of the folks that I think are allied with the way that I think about the Fourth Amendment, or the broader kind of like liberty-minded legal project, they're also involved in some of the bad judicial nominations that we've had and kind of the originalist movement. So there's a lot of, it's not like there's one contingent right now that's sort of like pure of heart and doing this all perfectly. It's sort of messy, and I wish it weren't.
I agree, and it's very messy. At the same time, I think doing the kind of thing Josh is doing, and the kind of thing, as some of you know, that some of us at ARI have been doing in recent years, speaking to Federalist societies. Federalist societies are mixed at best and getting worse. But you have some honest people in there. You have some honest young kids in law school, and if they're honest and they're bright, they'll hear, well, that guy had some really interesting things to say on the other side of this religious freedom issue, or, she had interesting things to say. So you still try to speak to the audience, because a lot of people in the law, I still do believe this, actually care about the law. And you can have some pretty rational arguments and change some minds with people in the law. I found that more than in philosophy proper.
This is a really good point. I mean, I think the legal system right now, the judiciary, is one of the better functioning branches of government. And it's the place where legitimate conversation about what the Constitution means and what the government's duties and responsibility, like it's the place where that conversation actually occurs. In large part, you don't hear, folks in the executive branch or folks in Congress talking about the principles that comprise our government and its legitimate functions. You hear that in the courts. And maybe they're right, maybe they're wrong, but at least the conversation is happening in a way that looks serious and feels serious.
So I think there's an elephant in the room. The warrantless arrests and invasions by ICE agents into um, into private homes and businesses across the country en masse. I was wondering if there are any cases being litigated currently against ICE or the Trump administration on the basis of the Fourth Amendment specifically. If no, why not? And if yes, then was just wondering if you guys provide a status update on the progress, because I'm not really up to date with the news on all that.
Yeah. So in terms of any systematic effort, because that kind of, I think that's probably what you're getting at. Um, there isn't really a systematic effort right now at tackling this problem. And there's a reason for that, which is one, it's moved very fast. Two, the administration changes tactics frequently. And so it's not like it's kind of a moving target in a sense. I'll tell you that we're looking a little bit into this to try to figure out, is there something systematically that we could do at the Institute for Justice about ICE home raids and that kind of thing. But the problem we've kind of run into, and I'll just be open about this, it's not like there's one way this happens. It's not like there's one form of it. And it's not like there's one, it's easy to challenge a statute or a regulation or something written down that says do things this way. It's harder when you just have a whisper from Tom Homan to ICE that says, go get all the bad guys, right? And then they kind of use all the means at their disposal. So it's a bit of moving target. It's something we're working on right now, trying to figure out, is there something we could do systematically? Part of why it's been difficult is that some of the raids are supposedly happening under knowledge of the fact that there are illegal immigrants there, and maybe like a patina of exigent circumstances, which is an exception to the warrant requirement. So if it's true that there's an emergency, if it's true that this is an act now or never situation, there's no legal way you could challenge that. It's just a question of, is that actually true when they assert that it is? And so that's a question that has a factual answer. We'll be looking more into it and hopefully try to come up with a solution to this, but it's a hard problem.
Let me add something on a related issue. This is not about the ICE raids per se, but it does have to do with the Trump administration's policy on immigration. And this is a case IJ has acted on. Financial surveillance. As some of you know, from the Bank Secrecy Act going back to the 1970s, that's just me trying to show off. Financial transactions of $10,000 or more must be reported to the government. The bank is required by law to keep records of these things. Early months of this new Trump administration, we're going to drop that from $10,000 for these 30, it's not counties, I think it's zip codes, along the Mexico, California, and Texas border, right? Because we want to intimidate immigrants and so on. We're going to drop it from $10,000 to $200. Excuse me, did she say that right? Did she say? Yes, from $10,000 to $200. Clearly, because they just want to go after these people who run certain businesses of cashing your checks or giving you a money order so that you can pay certain bills and so on, right? It's clearly trying to intimidate people into not doing certain things related to immigration. And IJ challenged it and has gotten some temporary restraining orders and things. So IJ has taken
we've
that
gotten
kind
3.
of case. Yeah, I'm sorry.
We've gotten 3 of them.
Yeah, like you've done well so far with it. Yeah. So
I'd like to add one thing, not that I'm in the position to comment on the legality, but 2 things for you guys to look at. One of my colleagues will be speaking later this week on the immigration raids and sort of the legal political side of things. That's Agustina Vergara Cid, who's speaking on that here at the conference. If you're here, I recommend going to that talk. The other thing I'd recommend that you might be interested in from a more philosophical perspective on this phenomenon of, and I appreciate your bringing this up, the use of government power to go after immigrants. And I think there's an element of that which is a show of authoritarian force, and it's an intimidation tactic. It isn't exclusively about finding criminals. And on that, I would recommend, we've done a number of podcasts for New Ideal, the Journal of the Ayn Rand Institute. One was at the time of the LA riots and the mass deportations and the reaction to that. The other one is about the arbitrary use of government power by the Trump administration. So if you haven't watched those, they're on YouTube. You can subscribe to our podcast. I recommend you take a look at that. Again, it's not specifically a legal question that we're addressing in those, but I think it'll give you some of the philosophical perspective that some of our scholars have at the Institute. Thank you.
Thanks, guys.
Next question.
Thanks for this discussion. My question's around national security interest, and specifically, how does the nature of Fourth Amendment cases change when national security contexts are enforced or claimed by the government? in particular about, what, purposeful or due process and things like that. Thank you.
At least in the Fourth Amendment context, I mean, the Fourth Amendment's text has the phrase unreasonable searches and seizures. And, I think there are ways to read that as squishy and non-objective, but, it doesn't strike me as odd or wrong for the Supreme Court to do as it has done, which is to say that, yeah, it's when you have weighty national security interests at stake, right? When you're trying to root out terrorists, you're trying to repel foreign invaders, you're trying to enforce our border policy, for example. Like immigration tends to be at the border, you tend to have more lenient, standards for Fourth Amendment searches and that kind of thing. That doesn't strike me as intuitively wrong or as obviously wrong. There might be ways in which the doctrine has overstepped or gone too far and given the government maybe too much discretion at the border or too much discretion when it comes to national security. But I think at a basic level, it does strike me as reasonable to say that when the government has like some of its core functions at stake, right? That's a place where, yeah, I mean, if we're repelling foreign invaders, if we're in a war, if we have a national security threat, like that's a context in which it makes sense to say, okay, maybe a warrant isn't required in this situation. Not all the time. And I mean, just to give you an example, we have like the NSA dragnet spying program of like sweeping up people's data that is supposedly tied to the war on terror that's been going on for decades. Like that's not an emergency, right? That's just the government wanting to spy on all of us.
Yeah, no, and I think, I mean, national security, that sounds legit. And it is legit, right? But it's got to be interpreted and applied in a legit way. And there's always the danger in it. Too often people have taken advantage and the government has taken advantage of, oh, you say national security, and it feels like we have to go along with this, right? Um, and it's a little bit, it's related just to the domestic side or the less national security against foreign invaders of different sorts of the law enforcement has to remain lawful, we're not against law enforcement. We're all for it. Appropriate searches and seizures, like, yeah, right. But it's got to itself be lawful. And similarly with invocations of national security, okay, lawful. But that's actually also an area that I want to think more about. That is like, what are some of the proper, I mean, I just think of Homeland Security and that, they're going to be looking at me again tomorrow. And me? Really? Me? You know? So I want to think that all through more. Like how much looser in general and in principle should things be at the borders or the airports? And is there a good case for that or not? That's one of the many questions here.
Thank you.
So fair warning to everyone in the queue. I think we will probably be able to take all of you, but we might only get to or two of you. So let's take your question, Miss.
Good afternoon. So this question specifically for Miss Tara, looking for more of a philosophical answer. But do you consider the Fourth Amendment to be a contradiction as it pertains to the open field doctrine?
I'm sorry, to which doctrine?
Open field?
Oh, the open field doctrine?
Yes.
You mean, do I think there's a tension between the open field doctrine that he was open fields that he was talking about, the way that's been
Right.
right, that's in violation of the Fourth Amendment? Yeah. As far as I mean, unless I'm missing something in the question, right? Yeah, I think the open field doctrine doesn't seem to make any sense vis-a-vis the Fourth Amendment. Am I getting you?
Yes.
Okay.
Yes.
Yeah. Oh, yeah. Yeah.
No, I wanted to ask if you had the ability to prevent loopholes like that or to
But
prevent.
sorry, go ahead.
I know you're fine.
So again, I don't think there's a loophole in the amendment or in the Constitution. I think it's been interpreted in a really stupid way, and then that interpretation has become entrenched, such that the court has been saying, "Yeah, all this land that's yours isn't really going to be treated as if it's yours."
Okay, and I heard Josh speak about it. At least in his perspective, if you could do anything to eliminate the false interpretations or misunderstandings, how would you go about it?
So there's a famous case from the 1920s called Olmsted versus United States. And it's about wiretapping. And it's a case where the Supreme Court applied this like very narrow textualist approach and said that, tapping the phone lines from the outside going into a house wasn't a search because it didn't physically intrude onto the home. And, they're searching for things, right? So it strikes me as a search. But setting that all aside, there's a famous dissent in that case. And it ends up, inspiring the Katz decision, and we can talk about whether Katz is legitimate or not. But there's a line from one of the dissenters that says the way we should be thinking about the Fourth Amendment is to apply a rule of liberal construction, and by that the dissenter meant let's try to figure out what this is all about. Right? Let's try to figure out the evils, the chief evils against which this was directed. What was going on when this was adopted? What was the context for its adoption? Why? What was this supposed to safeguard? What positive values was it supposed to protect? And then figure out, is what the government is doing today like and equivalent to those evils? So yes, the text is a great guide to that. The text is illustrative, but I think we need to get courts to understand that the text is not exhaustive of meaning. And if we can do that, and if we can kind of reset to grasping that the Constitution is designed to forbid certain evils and protect certain values, I think we're making a lot of progress towards closing some of these loopholes.
Thank you, guys.
Hi. My question is, do you consider these Fourth Amendment issues like another byproduct of the court and the Constitution not being considered, or the Declaration of Independence not being considered like the foundational document to the Constitution? And as your legal foundation, do you guys try to call on the Declaration of Independence to ground Fourth Amendment issues?
I think that is a big problem. I think the Declaration, properly understood, should frame a lot of the way the court thinks about the Constitution at a more basic and fundamental level. It's treated as not the law. The Supreme Court has said that over and over again. So that's kind of it's a losing argument in court right now. It at least informs the way I think about it. But I think kind of one thing to say is that even if the court were to change its mind and say, you know what, we're going to recognize the Declaration of Rights as part of the organic law of the land, right? Part of the problem we have today is that the court butchers whatever text it has in front of it, right? So right now, the point I made earlier about the Fourth Amendment and the open fields doctrine and this person's house's papers effects, like I think we can get to the right result there without looking much further than just the Fourth Amendment itself and the context in which it was adopted. But I also think the Ninth Amendment matters a lot. The Ninth Amendment says that the people retain rights that are not enumerated, and the court just totally ignores it. It treats the Ninth Amendment as if it doesn't exist. And if it's willing to do that with explicit parts of the Bill of Rights that are designed to prevent these kinds of misconceptions, it will do that with the Declaration of Rights, Independence too. And so I don't think that really the solution is to bring in more text to look at. It's to figure out, how do we interpret the text the right way?
Gotcha. Yeah, I just don't ever hear like originalists talk about the Declaration ever, only the
Well,
Constitution.
they don't like to think in principle about the Constitution. Thanks.
So I have a more fundamental question. How do you, or how do I say, how do you evaluate the fact that the Constitution is often interpreted in the zeitgeist or literate instead of in the original meaning? So how much value do you give to the idea of a constitution?
I want to understand the question better. How much value do we give to the Constitution, given that it's so often
Misinterpreted.
given that it's so often misinterpreted?
Yes.
I don't think the fault lies in the Constitution, in all honesty. I mean, I don't think, like, I could see, and I do sometimes see, like, reasonable disagreements about exactly how something should be applied. Like, life throws up new kinds of situations, and it's not always obvious, particularly in the beginning, how exactly certain of these provisions of the Constitution should be applied. But I mean, what we've seen in the courts in a number of areas is, I don't know even how to describe it, but it's very non-conceptual reading, sort of again, context dropping. I think a lot of them have been taken under the spell of textualism in that a contextual sense. And in a way, I mean, the way that a lot of courts think about the law is the way a lot of people think about all sorts of things. Rand talked years ago about concrete bound mentalities and people not being conceptual enough. And it comes back to bite you in all areas, including such a powerful, impactful area as how our laws are made and, today, and how they're understood. So there are thinking problems that go into this, again, as opposed to, I think, again, you can't write. I put it before. You can't write an idiot-proof constitution. A constitution is a statement of principles, or the principles are at least so right there under the surface of the kinds of rules that you're setting in a constitution. I think you need both the right kind of methodology, objective methodology of interpretation, but you also need an understanding of the ideas from the Declaration and so on, an understanding of the principle that your life is yours, and that kind of individualism that infused the Constitution.
Thank you. We're almost at time, so we won't be able to take your question just now, but you're welcome to find the speakers later. I'd like to turn back to you. We're already on this theme with the questions that have arisen. What would you do? I want to ask you, the theme of this session is reclaiming the Fourth Amendment. What thoughts do you have to share with us in conclusion about what you'd like to see done, what you're hoping to see? What are some pathways to success? And from your perspective, Tara, what sort of philosophical perspective would you bring to this?
I think a lot has come out in the course of our discussion, frankly, so I don't think I have anything all that fresh to add at this stage. But a few things I guess I would highlight. And I don't know, you want to keep coming up with fresh ways of putting it, so it's like, yeah, each individual is an end in himself. And we've got to appreciate that. I mean, that is just another way of putting individualism, right? And putting egoism in a way. But we've got to assert that unapologetically and try to get people to see that. It's like, no, my life is mine, to do with what I want. And we need a resuscitation of an understanding of individualism and a caring about, yeah, that's a wonderful thing that Elan has a life and that Josh has a life, and he should get to live it. I do think this thing we've talked about has been a very important and bad phenomenon of the reversal of presumptions here, whether we talk about the presumption of liberty in the constitutional context, but it's that presumption of, oh, everybody does something wrong, the warden in Ohio again, right? Or we're going to surveil everything because you're like a bunch of naughty children, and we know that if left to your own devices and unwatched and unmonitored, you're going to be like, no. That is not the premise that this country was built on, and it's not a right premise. It's not a correct premise. But I think this cynicism toward fellow human beings has taken hold somewhat. I mean, not everybody believes this, but there's been, anyway, so I think we need to reverse some of these presumptions and restore an assertion of the individual as an end in himself who has every right to be treated that way by the legal system.
Yeah, and I guess so how we go from philosophy and abstract principles to getting the law right is a science. It's very difficult. And right now you have a dominant ideology in the courts of kind of originalism and hardcore textualism that has a monopoly effectively on the way the law is moving right now. And there are some good things about that movement. They have some things correct, right? We want an objective, they think of it as objective, right? But we want to eschew subjectivism. We want to have a methodology. We want to be rigorous. We want to be scientific. Like we want to get this right. It's a serious effort to get it right. And I think it often gets it wrong. But the point is, like, there are good things and bad. And, our job in some of the more practical fields, when we get down to, earth from philosophy a little bit, is to try to translate some of these principles into actual answers and actual solutions. And I'll just give you, my approach to the open fields doctrine maybe is one data point that might give you some inspiration. So, like I said earlier, we have 50 constitutions that are not the U.S. Constitution. We have state constitutions, and they're all different. They're all magnificently different. Dr. Thompson talked yesterday about the fact that we had constitutions that predated the U.S. Constitution, right? We had one in every colony. And some of the most formative ones were the ones that adopted the first ever search and seizure clauses in the history of the Western world, right? Virginia and Massachusetts, before the U.S. Supreme Court, ever thought about the Fourth Amendment, before the Fourth Amendment was written. So for me, those state constitutions are powerful sources of protection for individual liberty, of security and people's property and their ability to pursue their happiness. And I'll just give you one. I know I have 11 seconds, but I'm going to take 30. I'm sorry. But we had a decision in the Tennessee Court of Appeals. I mentioned Hunter Hollingsworth's case about the camera in his tree. I'll just tell you the end of the story. The end of the story is that Hunter represented by my firm, sued the government in Tennessee to challenge the statute that authorized them to go on his farm without a warrant. And we got a decision last year. I'll just read this paragraph from it because I think it's going to inspire you. What the state is arguing is reasonable stands in opposition to the restraint upon reasonable searches and seizures that emerged from the American colonial era in opposition to arbitrary searches. What the state purports to be a reasonable search, each agent is empowered with the discretionary authority to determine for himself or herself if there's a reasonable basis to suspect hunting activities on the property. The state does not notify the property owners of its entries or keep records of the entries. How long and for how often their entries are concealed or not are matters of discretion for the agents to decide for themselves. These searches, which the state claims are reasonable, bear a marked resemblance to the arbitrary discretionary entries of more than 2 centuries ago in colonial Boston. This is a disturbing assertion of power on behalf of the government that stands contrary to the foundations of the search protections against arbitrary intrusions in the American legal tradition generally and in Tennessee specifically. And finally, simply stated, given the purpose of the state constitution of preventing arbitrary intrusions upon privacy and personal liberty, what the government is claiming is reasonable is not. And the point is, if we can get courts to say things like that, we can change the law.
Thank you, Josh Windham and Tara Smith. Please join me in thanking our panelists today.